Hello and welcome to Newsmax TV. I'm John Bachman. With us now on the phone from Richmond, Virginia, is Virginia Attorney General Ken Cuccinelli. Thanks for talking to us today.
Glad to talk to you.
Well, your state is one of 26 challenging the constitutionality of the Affordable Care Act. You've been inside the Supreme Court and heard the oral arguments. Give us your thoughts on how you think the court will rule now that the arguments are over.
You know, we filed within the hour of the president signing the bill in Virginia, and for 2 years I felt like I was cautiously optimistic of our prospects, and I never changed that position. That needle just didn't move over 2 years through Tuesday morning. But by the time I came out of the hearing Tuesday afternoon, I was a lot happier. And on severability this morning, that argument in particular, you may hear a wide variety of reportings of speculation of it, but it gave me more comfort still, both in the mandate decision and in the likelihood or the opportunity for the whole law to be repealed. I think that I'm as upbeat as I've been in the whole 2 years and 5 days now since we filed.
On the severability issue, today we heard Justice Anthony Kennedy ask a lot of what-if questions, as in what if we strike down the individual mandate. We also heard a similar question from Justice Sotomayor. Now, Kennedy is being looked at as a potential swing vote in this case. Do you feel like he may have tipped his hand based on the line of questioning, especially today?
I don't know tipped his hand is the right word. I think there were points when certain justices, including Justice Kennedy, declared a position. And I don't mean I'm going to vote or I'm not going to vote. I mean with respect to issues in the case. For instance, Justice Kennedy, when talking back and forth with the representative of the U.S. government, Ed Needler, he said, look, you're calling judicial restraint the notion that we should strike down as little as possible or only small amounts, and I think you might have it quite opposite, meaning Justice Kennedy. He thinks it's more restrained, potentially, if you leave the Congress in America with a bill that is really only a fraction of what Congress passed, that treats insurance companies in ways that Congress had never intended. And he said, and I quote, by reason of this court, the reasoning, I mean, we would have a new regime that Congress did not provide for and did not consider. That, it seems to me, can be argued at least to be a more extreme exercise of judicial power than even striking the whole. And Ed Needler said, oh, I think not. And Justice Kennedy said, I just don't accept the premise. That's a statement of position. And the premise he doesn't accept is that doing less is actually more judicially restrained than striking the whole bill. That's a very interesting thing for him to say.
Well, polls do show that most Americans want the individual mandate tossed, but at the same time, provisions like allowing people to stay on their parents' health care or health insurance until they're 26 and prohibiting health insurance companies from excluding people with pre-existing conditions and healthcare exchanges, for example, are proving to be pretty popular amongst the public. Do you see any scenario in which the more popular provisions can survive under the law, or do you think an entirely new law might be necessary here?
I think an entirely new law might be necessary. I do think there did seem to be, I wouldn't call it agreement, but there seemed to be a consensus that the least that would be stricken if the individual mandate is found to be unconstitutional, the least that would be stricken is the mandate, along with guaranteed issue and community rating, which basically the private reforms and the individual mandate that go with it. So I think all of those going is the minimum that goes. The question for states, the budget question for states is, does the Medicaid piece go? Because just in Virginia, in the next 10 years, that'll cost us nearly $2 billion, and that's if the federal cost estimates are right, and they never are.
What can you do on the state level to offset those costs? I mean, I think a lot of people can agree that it falls into the category of getting more people to pay their own way. What measures do you think will be effective to get more people to pay their own way when it comes to health insurance?
Well, when I was a state senator, before I was Attorney General, I tried to get a bill passed to allow Virginians to buy health insurance anywhere in the country. That was struck down. I think now things like that will have a much better choice. A lot of people don't know they are not allowed. It is illegal for them to buy health insurance outside of their own state. Well, what does that do? It shrinks the market for competition radically. If we knocked those barriers down, then I could buy it anywhere, and all the Virginia companies would have to compete with all the companies in all the other 49 states. That's one way to do it. Another is the simple expedient, and everybody talks about it, but nobody ever does it, is make people equal to corporations in the tax treatment of our health insurance. Companies get a tax break for providing their employees health insurance, but we individuals don't get a tax break for providing it for ourselves. That's ludicrous. It's outrageous. The list like this goes on, and what you will find on my list is a continual drive to get back to market discipline. And we've only had at the federal level one solution to every problem in healthcare for 47 years, and that's more government. Ever since Medicaid, Medicare went into existence in '65, and as Dr. Phil would say, how's that working out for you?
Referencing Dr. Phil there, I like that. Well, the oral arguments are just a portion of what the justices will use to make up their minds here. They will now get together, of course, in conference and start working on their opinions. What are some of the other factors that you think will come into play as the justices make up their mind?
Well, there were about 150 briefs in this case, and there are a few that are particularly good that I think will get a lot of review. The FRC brief on severability is spectacular. I think that some of the perspectives, some targeted perspectives that some outside groups have brought to things like the application of the necessary and proper clause, which was discussed yesterday, and Justice Scalia leaned forward and said, it's necessary and proper. We have two cases where we found things to be necessary to the regulatory scheme at issue, but not proper. Why is this proper? So you're going to see some necessary and proper discussion as well. But now it goes into a black box. I mean, the briefs are in. There's nothing else any of us can do except hope and pray, I suppose, for an outcome that preserves the foundation of our country, because that's very much what's at stake here. This case was not about health care. It was about liberty.
Let's take all the politics out of this interview for just a second, if you don't mind. As a lawyer and as an attorney general for the Commonwealth of Virginia, how exciting was it for you to sit in the Supreme Court and listen in on such a historic case?
Well, let me tell you, I don't get nervous about much of anything these days anymore. But as we approached the hearings, I had a twinge of it, and it's because I've never ever been involved in anything, and probably never will be involved in anything, where so much is at stake relative to our country. And it's very humbling, for sure, as a lawyer. Paul Clement did a spectacular job. He really set the bar. Mike Carvin did well for NFIB, but those guys really made the other side just not look very talented when they are talented. Didn't help the government lawyers to be dealt a lousy hand of cards they had to play, both legally and factually. I mean, when Justice Scalia can say to you, well, the president said this wasn't a tax before, now you're here saying it is, right? What am I supposed to do with that? That's a difficult position to put a lawyer in. It's been a real honor to be part of this process. I wish we didn't have to. I wish that the foundation of our country wasn't under this kind of legal threat, but it is. And when I campaigned, I said that if the federal government crossed these kinds of lines, I would push back, and I'm doing it.
Well, lastly, you have officially now filed your papers to run for governor of the Commonwealth of Virginia. What will be the focus of your campaign?
Well, for 2012, the focus will be building. Virginia is a swing state for the presidential race, and it's the most important election of my life. So my first goal is to make sure the Republican wins this state for president. My second goal is to make sure our Senate candidate wins this state for the U.S. Senate, because the Senate is also critically important and very much in play this year. And while doing that, I'll do some fundraising. People can sign up for our our team at Cuccinelli.com, www.cuccinelli.com, and we hope they would. I've been doing analysis every day that I've been mailing out in the Cuccinelli Compass, our email newsletter, first-person analysis, and I'll keep doing that. And we'll do fundraising and recruitment this year, but all in the context of helping our candidates win. And then it really kicks off, and we'll get energized for 2013. We're an odd-year election. So we're not till 2013. I'll have a primary in June of 2013. I'm very honored to have heard on the radio last night Mark Levin endorsed me, and I didn't know it was coming. That was a pleasant surprise. I think there'll be a lot more of that. I think that we've done a good job in the Attorney General's office, and that over 400 people get credit for that. But that kind of track record is a good one, I think, to carry into the governor's race.
All right, very good. And Virginia Attorney General Ken Cuccinelli, great talking with you today here at Newsmax TV.
Always a pleasure. Thank you.